and constitution and sorry,
Okay, got it.
sociological approaches to criminal and constitutional law. My name is Stephanie Didwania. I'm an assistant professor here at the University of Wisconsin Law School, and I'm so excited to be moderating this panel and looking forward to learning a lot. So the way that we decided this panel would work is that we should hopefully have 3 speakers who will each speak for 20 minutes. And then we'll use the remaining time, which will probably be around 40 minutes for Q&A. For the Q&A, I can keep the queue, and the easiest way to indicate that you would like to speak is by raising your hand in Zoom or putting a note in the chat. So our first speaker is Professor, oh, she's here.
Oh, there's Anna, good.
Our first speaker is Professor Nancy Combs. Professor Combs is the Ernest W. Goodrich Professor of Law at William and Mary Law School and Director of the Human Security Law Center. Professor Combs is a graduate of UC Berkeley School of Law and has a PhD from Leiden University. She is a leading expert in the field of international criminal law, and we're going to hear her talk about the impact of separate opinions on international criminal law.
Thanks so much, Stephanie. You can hear me okay? Great. I really appreciate being here and having the opportunity to talk about this paper. The paper is part of a larger project, which I hope will result in a book eventually, but it's the first component of it. And the topic is separate, as the title indicates, is separate opinions in international criminal law. As some of you probably know, separate opinions, although very well accepted in the United States and common law countries, are not so accepted in continental Europe. And so in a number of jurisdictions, all of the opinions are issued per curiam. And if you are in the minority, you just don't say anything about it. When international tribunals began being established at the turn of the century, separate opinions were also sort of a very highly contested question. But they were accepted in the Permanent Court of International Justice. And from there was pretty much no looking back. The European, the only major international tribunal that doesn't accept separate opinions is the International Court of Justice. But in any event, my focus is on international criminal prosecutions at international criminal tribunals. And I focus on 4: the International Criminal Tribunal for the former Yugoslavia, the International Criminal Tribunal for Rwanda, the Special Court for Sierra Leone, and the International Criminal Court. And all of these tribunals allow separate opinions and have plenty of them. There also has been almost no scholarship on these points, so this is a fairly fertile source of inquiry. My goal in this project is to be both empirical as well as normative. There's a lot of normative claims that are made about separate opinions, both domestically and internationally. And in this piece, as well as the companion pieces, I seek to empirically test a number of these claims. In this piece in particular, I'm looking at the impact of separate opinions on the development of international criminal law. Separate opinions are often credited with helping to develop the law. You hear this in the domestic context as well as internationally. And so I'm seeking to ascertain whether that claim has any empirical legs. Is there any evidence to suggest in the international context, in the international criminal law context, do separate opinions have an impact? The short answer to my question is I find no evidence of that. But let me start off by providing some just basic statistics. In fact, I need to share my screen. Let me do that. Share there. Okay, looks like you can see that, right? All right, so let me start off by providing some statistics on the prevalence of separate opinions in international criminal law judgments. The short answer is that they're quite prevalent, particularly at the appeals chamber level. So at the trial chamber, you can see 37% of trial chamber judgments have at least one separate opinion. A whopping 78% have of appeals chamber judgments have at least one separate opinion. I have to find myself not distracted by the people who are coming in. it's a funny thing that in the classroom, it doesn't distract me at all when students come in late. And I often find students will come in afterwards and apologize for coming in late. And I'm hesitant to say, well, actually, I didn't even notice. But in the Zoom context, when people are coming in, I do find, oh, who's that? So forgive me if you see me a little bit distracted on that front. In any event, overall, with appeal and trial chambers, about a little more than half of international criminal judgments contain at least one or more separate opinions. This compares similarly to United States Supreme Court opinions. About 60% of US Supreme Court opinions have at least one or more separate opinions. And it's dramatically more than Court of Appeals opinions, where Federal Court of Appeals opinions, typically about 10% of them have one or more separate opinion. In any event, so I performed 4 tests to assess the influence of separate opinions in international criminal law. The first looks at the percentage of trial chamber separate opinions that contain a point that is accepted on appeal. Okay, I see that as arguably the most direct form of influence that a trial chamber separate opinion can have. And then I go on and, we'll talk about this later. I do some citation counts. This is kind of a tried and true method of assessing influence. And then I do a content analysis, and 2 different kinds of content analysis, which I'll talk about as we go on. But turning to the percentage of trial chamber separate opinions that contain a point accepted on appeal, we see that the short answer is about 14% of trial chamber separate opinions contain a point that is accepted on appeal. You can see a high divergence between concurrences and dissents. Concurrences have basically no influence, 0 in this realm, in this way. 0% of concurrences contain a point that is accepted on appeal, whereas about 22% of dissents do. Now that number sounds reasonably influential. About 1 in 7 separate opinions trial chamber separate opinions contain a point that is accepted on appeal. There are some factors, however, that indicate that maybe the influence is less than that. For one thing, although 1 in 7 trial chamber separate opinions contain a dissent or contain a point accepted on appeal, the appeals chamber almost never cites the separate opinion. So it's a little difficult to know whether or not that separate opinion was influential. In particular, something like 10 out of the 12 appeals chamber judgments that accept a point raised in a trial chamber separate opinion fail to cite the separate opinion. And that despite the fact that 11 of those 12 cases, the litigant highlighted the separate opinion. So it's not as though the appeal chamber was unaware of it or should have been aware of it. I also wanted to see, I'm going to go to a next slide here, how often appeals chambers just reverse trial chamber judgments on one or more points, whether they had a separate opinion or not. I compared the 2. You can see that, and I'm going to move you over there. Yep. You can see that even in unanimous trial chamber judgments, nearly 3/4, 74% of trial chamber judgments are reversed on at least one or more point, even when they're unanimous. And this compares very similarly to non-unanimous trial chamber judgments. So non-unanimous judgments, or said differently, a judgment with a separate opinion is only slightly more likely to be reversed on one or more points than a unanimous judgment is. Finally, even in those trial chamber dissents that do contain a point that is accepted by the trial chamber, they also contain a lot of points that are not accepted by the trial chamber. So I just trying to contextualize this number of 14% of trial chamber separate opinions contain a point that is later accepted on appeal. Next, let's look at citation counts. As I said, I did 2 kinds of citation counts. First, just to gain some understanding of how often separate opinions are cited, I canvassed the entire body of international criminal law final judgments, both trial and appeal, in the 4 tribunals that I mentioned, as well as 2 other newer tribunals. and just, assess what percent, how much were these separate opinions cited. And I'll show some statistics on those. I also read the citations. I didn't use a mechanical means of counting, but I actually read them because I think placing those citations in context gives us a fuller bodied picture of the actual influence that they had. But in addition, I don't think you can just look at the separate opinions, but rather I compared citations to majority opinions with citations to separate opinions. But all right, let's look at the statistics. If we're just looking at citations to separate opinions, we see that 53% of separate opinions are cited at least once, okay? And the average number of citations that a separate opinion receives is 2.25, okay? Now, if we divide by the tribunals, you can see that there's a pretty substantial difference. So the Yugoslav tribunal, known by the acronym ICTY, their separate opinions are cited dramatically more than other tribunals, almost twice as often as ICTR and ICC separate opinions, and nearly 4 times as often as SCSL opinions. Did I have that right? Sorry, I think it's the other way around than ICC opinion. Sorry, I'm not able to see my own statistics because you're blocking it. There is there's a narrative in international criminal law that there is a pro-European bias, and that the opinions of the tribunal that is located in Europe and that contains or that concerns European atrocities may be more influential than other tribunals. And this set of statistics, I'm not opining about that narrative more generally, but this set of statistics would support that by virtue of the fact that the ICTY's separate opinions are cited considerably more often. But then, as I said, I actually read all the separate opinions because I do think that just, counting citations is kind of a simplistic or maybe overgeneral way of assessing the influence. And so I looked at the citations to determine, what they were cited for. And so you can see I've classified these as in 7 categories, going from the most influence to the least influence. The most influential are those citations that are in the same case, that are by a majority opinion, and either the same or a different case. If you look at the bottom 3 categories rather, I would suggest that these are completely influential or maybe even anti-influential. Number 7, for instance, is a citation that is for the purpose of rejecting the separate opinion. It's very hard to call that a citation that reflects influence. Number 6 is citations by the author of the separate opinion. What we find is that the certain judges pen separate opinions on particular points, and although those separate opinions never are actually convincing enough to become the law, the judge continues to cite them in additional separate opinions, so on the same point. So, and they'll make the same point and then cite all of the previous separate opinions in which they've made this point, which thereby drives up the citation to the separate opinion, but doesn't suggest any additional influence. And finally, citations by a litigant. Unlike in the United States, where litigant arguments are not, carefully and laboriously described, in the international criminal context, these judgments will, in a very detailed way, describe the claims of each litigant. And in doing so, they will cite the things that the litigants cite. So category number 5 concerns litigant citations, where the judgment simply says, claimant asserts blah, 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 and then cites the separate opinion. I would argue that each of these 3 really does not reflect any sort of influence. If the citation by a litigant had been accepted by a majority, then it would have been categorized as in citation by the majority opinion. So let's look at, we have just, if you classify by citations, there were 567 citations to separate opinions across all of the majority and separate opinions in these tribunals. You can see that the bottom 3, uninfluential citations comprise about 45% of all of the citations. And only a little bit less than a third would be what I would call citations that reflect real influence in a majority opinion. We can also, categorize by the separate opinion themselves. And we see that if you look at the cited separate opinions, I initially said that something like 53% of them were cited at least once, but 22% of these were cited only in those three, what I would call uninfluential or valueless ways. And only 27% of opinions, separate opinions that were cited once, were cited in a majority opinion. Okay. The next thing I did is, as I said, I did a citation count that compared citations to majority opinions with citations to separate opinions. And I think this is necessary because it's the only way to really put into context what a low citation count is. If you don't know, maybe the international tribunals don't cite much of anything. So few citations to separate opinions doesn't tell you anything in and of itself. And in a matter of fact, I kind of followed the lead of some seminal work by Epstein, Posner, and Landis, who looked at the influence of separate opinions in American jurisprudence. And they found, by doing the same kind of analysis, a comparison between majority and separate opinion citations, they found that dissents in courts of appeals had basically zero influence based on their ratio. What I did methodologically, whereas the previous citation count that I described, I actually looked at every page of every judgment because I could not do that for purposes of, do I have, 5-minute warning, thank you. All right, I will make sure to close up. I did a sampling rather than a comprehensive assessment because the international criminal law judgments are too voluminous. But let me show you, whoops. You can see, and because I'm going to go a little more quickly, the bottom line numbers are at the bottom. Basically, the average citation per majority opinion is 8. The average citation per separate opinion is 0.074. So you can see 108-to-1 ratio between citations to majority opinions and citations to separate opinions. If we compare that to the Landis, Epstein, and Posner study, you see that they were claiming that there was almost no influence of American dissents, particularly in the Court of Appeals, and the ratio at the International Court is even higher. Okay. You can just have a brief look at this. I won't bother describing it. I finally did a content analysis to examine, just to get a sense of what are these separate opinions about and how likely are they to have had influence over the course of international criminal law. First thing I did was distinguish between, whoops, this is not what I want. No, where did that go? That's in the wrong place. I'm sorry. The first thing I did was distinguish between dissents that contained only legal points with dissents that contained factual points and dissents that were equally divided between both. And I did this because factual dissents are necessarily going to have dramatically lower influence. A trial chamber factual dissent might have influence in an appeals chamber, but an appeals chamber factual dissent is not going to have a influence anywhere else because the facts are not the same anywhere else. So you can see that the way I describe it, approximately 40% of dissents contain only factual points, and we can assume that the only possible influence they can have is over the appeals chamber in the same case. And even there, that influence is very limited. Let's see, I just want to think about what else do I want to say. Yeah, all right, let's move on. And methodologically, it's actually kind of difficult to figure out what is a factual point and what is a legal point. It can be fairly straightforward. But in questions relating to the application of law to fact, I classified those as legal because I wanted to give separate opinions the benefit of the doubt, as it were. In any event, these are the numbers that I came up with. Then I looked at the content of, and that's what I'm gonna make sure I don't want to go over time. I want to make sure I looked at the content, looking only at the legal dissents, only at the legal issues. I divided them into something like 85 legal categories. What I found were most of them were one-hit wonders, that most dissents contained issues that appeared only once or twice in separate opinions. And it could be, we could dispute about how I divided things, and my way is certainly not the only way. But regardless, I think we can say that there are a lot of issues that just do not have continuing appeal. They are not of widespread appeal. They appear only a couple of times at the most. You will note that this is the list of the issues appearing most frequently. You will note that they don't contain a lot of issues regarding crimes and defenses, which is a little bit surprising. Finally, what they do show is that most of the issues that appear most often are what I would call issues of application of law to fact, right? They're not precise legal issues, but they're issues where the majority and dissent agree about the law. They agree what the legal standard is. The majority and the dissent agree about the facts. What they disagree about is the application of that law to fact, right? So we might agree that about the standard for accomplice liability. We might agree that the defendant drove the attackers to the massacre site. So we agree on the facts, but we disagree about whether driving the offenders to the massacre site equals a meeting of the accomplice liability standards. All right, I can't tell when the 1 minute warning was given. Am I out of time, Stephanie? I am out of time. All right. Well, I will stop here.
Perfect timing.
There's always more to say, but I want to make sure I stay on target so that other people have their requisite time. But as I say, the short answer to my question is through a number of tests, it is my belief that international criminal law separate opinions have not had much influence on the development of international criminal law. Thank you so much.
Great, thank you so much. And for anyone who joined us a few minutes late, the way that this panel is proceeding is that each speaker is going to speak for about 20 minutes, and then we'll have a Q&A where questions or comments can be directed to any or all of the panelists. So our next speaker is Professor Noah Novigradzki. Professor Novigradzki is the Carl M. Williams Professor of Law and Ethics at the University of Wyoming College of Law. Sorry, fix my thing. And the director of the Center for International Human Rights Law and Advocacy. He is a graduate of Yale Law School and holds a master's in international relations from the University of Cambridge. And he is a leading expert in the field of international human rights law. And he's going to talk to us about winning transnationalism. So take it away.
Thank you very much. Can you see my PowerPoint all right? Great. It is the worst PowerPoint in the history of PowerPoints, but I thought for a 15-minute presentation, it might help us stay on track. My work in progress is called Winning Transnationalism. And I note for this audience that international and comparative law scholars have written extensively about the migration of constitutional norms and the practice of high courts engaged in borrowing or cross-referencing decisions from foreign courts. But less attention has been paid to the question of how effective transnational advocacy occurs. So based on recent experiences litigating equal marriage and contraceptive coverage questions before the United States Supreme Court, I'm at work on a paper that examines how lawyers marshal arguments and favorable case law across jurisdictions to facilitate the adoption and uptake of ideas, especially when the object court need not do so. So I'm not talking about small Commonwealth common law countries that reflexively cite precedent from other states in the same tradition, one-time appellants before the Privy Council, for example, right? I'm talking more about how do you influence the United States Supreme Court with an idiosyncratic form of exceptionalism, and other courts that have exhibited some resistance to the adoption of foreign and comparative law for use in their own interpretive undertaking. And my tentative conclusion is that winning transnationalism requires three elements. First, a direct appeal to first principles. Second, a translation of the foreign and comparative discourse into well-tested domestic legal terms. And third is a declarative request. This is a pitch to judges, not legislatures, to embrace a uniquely judicial function. I have a unique vantage point in that I have litigated transnational cases, first as the director of the International Human Rights Clinic at the University of Toronto Faculty of Law, and more recently as the director of our Center for International Human Rights Law and Advocacy here at the University of Wyoming. Let me say a word about what we are not talking about before I get into what we are talking about. So we're not talking about international tribunals which invoke international, foreign, and even scholarly writings into their analysis. And I'm not talking about advocates and allies working across jurisdictions to share best practices or provide local solutions to problems that exceed the interest or capacity of any one state to regulate. What interests me is how advocates use foreign and comparative exemplars before domestic judicial bodies when the court need not, but often does, look to foreign and comparative law. And I've identified what I'm going to call 4 generations of this work. The modern migration of norms and precedent begins with the Commonwealth tradition of harmonizing laws across an empire upon which the sun never set. So it's no surprise that tiny Belize would look to the High Court of Australia or Canada to resolve the question of whether Mayan communities hold Aboriginal title to lands they have traditionally used and occupied. Or that the South African Constitutional Court would look to other common law jurisdictions for guidance on whether the death penalty conforms with South Africa's new constitution. Or that Singapore and Ireland would examine each other's antitrust or competition rules. So this is transnationalism 1.0, which I think is the modern instantiation of Commonwealth common law borrowing. But more recently, progressive human rights advocates have sought to extend norms and principles from a place that has adopted their or our viewpoint and transplanted it into another state that has not adopted that viewpoint. So for this proposition, look no further than the amicus brief of former UN Human Rights Commissioner Mary Robinson submitted in Lawrence versus Texas. Full disclosure here, I am a student of Harold Koh's. Harold and I have joined forces in a number of these cases, and I consider myself part of an effort to apply progressive human rights norms adopted in one context, sometimes in another. So that's where I'm coming from. In Lawrence versus Texas, the amici urged the Supreme Court to follow the European Court of Human Rights decision in Dudgeon which struck down a law banning consenting same-sex intimacy. And Justice Kennedy's decision obliges. He does just that, right? And cites Dudgeon approvingly as confirmation of the court's due process reasoning and dignitarian rights analysis. And in short, liberal human rights advocates enjoyed success not only before the United States Supreme Court, but in South Africa, in Israel, and in some other places, pushing a global rights vision for adoption under domestic, usually constitutional analysis. So let's call this transnationalism 2.0, and it was the dynamic of the early 2000s growing liberal internationalism. Perhaps unsurprisingly, this was met with a backlash, most famously or infamously in Justice Scalia's dissent in Roper versus Simmons, in which he asserted that the basic premise of the court's argument that American law should conform to the laws of the rest of the world ought to be rejected out of hand. What's interesting is that Justice Scalia's resistance to taking precedent from one location and adopting it in the United States was echoed by jurists in Australia and India, all of whom were saying that issues were non-justiciable, they were questions for Parliament to decide, that positive law only ever looks to domestic authority, and to keep the foreigners out, including with their legal arguments. So Nancy, perhaps this would be of interest to you, but I think that Justice Scalia's dissent echoed loudly around the world in conservative legal circles and emboldened people to say, not in our country, not on our watch. Right? Of course, state legislatures, particularly in red states of the United States, went further and included things like anti-Sharia law or anti-foreign law citation legislation. Vicki Jackson has called the resistance and engagement with the transnational an in-between space between adoption and outright rejection of the foreign and comparative. So I'm going to call the kind of late 2000s, early 2010s period transnationalism 3.0. So there we had the liberal human rights advocates pushing an agenda and the conservatives pushing back. More recently, conservatives have begun marshaling their own foreign and comparative law arguments before the United States Supreme Court, before the International Criminal Court. And this is an interesting story, which I think basically means that conservative legal scholars have joined their liberal brothers and sisters in arguing that foreign and comparative law matters in these important cases, just not in the way that the liberals say that it matters. So their basic argument is that the views of other countries are fully compatible with the position they're taking. These briefs usually qualify the salience of international practice by saying, of course, foreign law and practice cannot and should not be the determining factor, but it's influential or persuasive or educational. right? And this is happening big time. Part of what's happening is that there's a group of liberal internationalists, and I count myself as one of them, who have argued consistently in a number of cases that foreign and comparative law matters. And now there's a group of BYU law professors and others who say that foreign and comparative law matters, just doesn't matter the way we think it matters. And this was present in Dobbs versus Jackson Whole Health, the Supreme Court case on Mississippi's abortion law. And the New York Times, Adam Liptak had an article about this on October 4th, which I thought was quite convenient for today's presentation. And the only reason why I'm trying to do a PowerPoint presentation is to get the slide in front of all of you to show that this is a hot topic. So now foreign and comparative law is being used on both sides of debates, and I'm trying to understand when it works and when it doesn't. So let's call this transnationalism 4.0. Now, one explanation is it depends on who submits the brief. So a respected organization or individuals might gain traction for their views, but fringe voices do not. There may be some truth in this, but I'm suspicious of the argument because it ignores the craft and substance of a growing practice. And in this respect, I have identified 3 factors that I think contribute to whether foreign and comparative law is adopted or resisted in a given case. I'm calling the first factor confirmation, which is not direct precedent from a foreign context, but an actionable reference to values and ideas that exist both within and outside the state. So to do so requires the advocate to address the reasoning behind foreign and comparative law decisions and explain why this decision is likely to resonate in other places. And my intuition is that educating the court as to the global consequences of the case is likely to make it more receptive to foreign inputs. This is the dialogic appeal, and it obviously plays better in those cases involving matters that have consequences beyond a state's borders, global antitrust cases, citizenship and immigration matters, indigenous rights and climate change cases, same-sex marriage involving partners of different nationalities, internet speech, and possibly, and this is a new area that Diego Zambrano and others have been writing about, product safety and liability questions, particularly with respect to COVID vaccines, right? If a COVID vaccine has been held to be not helpful in Europe, I can imagine that that would go a long way to determining whether it's accepted in another jurisdiction. Comparisons matter. Plainly, some countries and contexts count more than others. And in this respect, Kenji Yoshino and I have been arguing for models and anti-models, as have others in this area. And my suggestion is that liberal democracies with independent judiciaries serve as a better model than authoritarian states. But that might not be true in an antitrust or a product liability case. Additionally, it's clear to me that while numbers are important, they shouldn't be the deciding factor. So a trend is more significant than absolute numbers. And this is my pet peeve, but the conservatives who join the debate are fond of saying, whatever outcome we like or don't like is present in 121 countries. But if those 121 countries have very little in common with our constitutional tradition, I submit that that is problematic. Second point here should be less controversial, that transplanting the foreign and comparative law is better if you can analogize to a well-worn domestic legal concept. The Mary Robinson brief in Lawrence versus Texas does a masterful job of this, echoing domestic understandings of decisional privacy, relationship privacy, zonal privacy. The Mugasera case before the Canadian Supreme Court discusses what incitement to genocide would look like if it had been committed in Canada. At that point, this is exactly the kind of borrowing and migration of ideas that most advocates are hoping for. Right? In this regard, it's easier to do it in a constitutional case than it is in a statutory case. Statutes are the product of peculiar histories. I think this was particularly true in the Hobby Lobby case on contraceptive coverage. And I have seen this in a host of other countries. So in that regard, I think translation applies better when you're translating to a big, broad document as opposed to a very specific statute. And finally, I think we're talking about seeking a declaration, and this is a particular appeal to judges. It's an invitation for courts as storytellers to connect one country's problem solving with that of foreign and comparative examples. Put differently, I do not think that this works with respect to parliamentary debates. In the crafting of legislation, very few countries want to say, well, we're going to do it exactly like another country did it. Interestingly, when New Zealand adopted an assault weapons ban, they were very careful to talk only about New Zealand examples and not what even neighboring Australia had done, which I thought is interesting. This is essentially an expressive exercise in front of judges. I have 3 quick questions, Stephanie, if I have enough time to pose to the group, because this is a work in progress, and I'm in Wyoming in the snow here, and I don't have a whole lot of opportunities to ask you all for input. So first question is, I'm trying to examine global opinions, not just United States Supreme Court decisions. And I'm looking to some antitrust and commercial cases for which cases transplant better than others, not just human rights cases. So my question is, what is gained and what is lost with a broader lens? Should I focus more narrowly on the stuff I'm more familiar with, or can I say something about winning transnationalism beyond human rights cases in front of the Supreme Court? Second is, if experiences of other states matter, which states matter more? Is there a sense that similar constitutional democracies should form the basis of comparisons? Or should we begin to think differently? So Sital Kalantri has written a recent article called Reverse Legal Transplants, the way legal transplanting is happening now, finally, from the developing world to the developed world. And I think that kind of explodes our assumptions that somehow well-respected global high courts from rich countries have answers that are worth sharing, as opposed to solutions or precedent worked out in developing countries. And the last question I have is, what kinds of cases are more amenable to comparative and foreign borrowing? I've been looking for climate change cases because my thesis was that there would be a lot of borrowing there. And there's very little of it happening in that area. And so I'm seeing a bit more of it in rights of nature cases, a lot of it in antitrust and product liability cases. And of course, we know about some of the human rights transplants that have occurred. I would invite those of you who are much more knowledgeable than I am in the comparative law world to educate me as to what works and what doesn't. I'm out of time, and thank you for your attention.
Thank you so much. So now we have our next speaker is Professor Anna Offit, I'm pronouncing that correctly, who is an assistant professor of law at SMU Dedman School of Law. Professor Offit is a graduate of Georgetown University Law Center and has her PhD from Princeton. She's a leading expert on prosecutorial ethics and the jury system in both the US and abroad, and she's going to talk about prosecuting rape in Norway. Go ahead.
Thank you so much, Stephanie. Thank you for moderating this. I'm going to try to share my screen here. All right. So I really appreciate the opportunity to think out loud about next steps in a project I've been working on since about 2017, where I went to Norway with Fulbright support and was very interested in a moment where the Norwegian legal system appeared to be dispensing with an all layperson jury that typically presided over appellate criminal cases. So I'll give a little bit of background on that, talk about some of my research findings, and then pivot toward applying some of these findings to the particular question of whether prosecuting rape in Norway challenges the conventional wisdom we otherwise see in place related to lay participation in the legal system. And what interests me more broadly is how lay participation operates in the legal system, not just in the United States, but also abroad, taking Norway as an illustrative case here. So in recent years, politicians in Norway, after decades of debate, moved to replace the all layperson juries. These were juries of 10 people who deliberate behind closed doors, much like the way that American juries deliberate, sought to replace these bodies with mixed courts. So in some contexts, they're referred to as mixed tribunals of lay and professional judges that would deliberate on the evidence side by side and then jointly determine sentences. So after a 2014 proposal to repeal the all layperson jury system was submitted to Parliament, the Progress Party joined the Conservative and the Labour parties in support of this move, to eliminate all layperson juries. And then finally, on January 19th in 2017, politicians reached an agreement that all of the all layperson 10-person juries in appellate criminal cases would be abandoned. So this surprised me. What this shift meant essentially is that there'd be an increase in the number of lay judges who previously presided in appellate cases. So what we would then see in the run of cases from the lowest cases of first instance up through appellate criminal cases are essentially mixed courts of lay and professional judges. This motivated a research project I engaged in. I'm trained as a cultural anthropologist, so I do qualitative legal research. So in focusing on Norway, I first was interested in, how could this be at a moment when liberal democracies around the world are incorporating only more lay participation into their legal systems? Why was Norway on the precipice of abandoning, this critical dimension of lay participation, so far as we had lay people without professional judicial interference deliberating alongside one another and rendering verdicts the way we see occur in the United States? So I'll talk about this research question, research design, and some of these findings. The question is, why was Norway preparing to do this? It was this because, and there are different hypotheses that jury scholars and comparative jury scholars have advanced for this. Is it because of lack of trust in lay decision makers? We simply don't trust lay people. Some of these arguments surface in context of American jury scholarship. Is it because we're always going to presume there's going to be state coercion at the point when professional judges are sitting alongside lay people and deliberating? That's another common concern. Or, right, are we looking more broadly, and legal historians have written about this, at an erosion of lay involvement in the legal system? So these were in the back of my mind approaching this project. And one I'd say a colleague and friend, I think, put this very well in an article she wrote in noting, quoting here from her, by law, professional judges are put in the leading role and given additional procedural rights and duties that lend themselves to leadership roles in the tribunal. Here she's referencing mixed courts. In these circumstances, cards are stacked against lay judges. It's simply not fair to expect lay judges to be as active as professional judges in the decision-making process. So a very critical take, right, on mixed courts, mixed tribunals of lay and professional judges sitting alongside one another, as opposed to all layperson juries. So I approached this question by carrying out interviews with judges, also prosecutors and defense attorneys and former jurors, and also some former lay judges, since these mixed courts were operational in lower criminal courts. I also observed trials. I speak and understand Norwegian, but some of these cases were also carried out with English language interpreters, which was interesting and helpful insofar as non-Norwegian nationals were on trial. And then I've been reviewing other comparative jury scholarship that we've seen in this area. So the findings, right? So first, I was interested to learn that the lawyers, the judges I interviewed, viewed the mixed court as an egalitarian and actually a more transparent alternative to the jury system. So where I asked them, why are you abandoning the all layperson juries that you've had and your Anglo inheritance of this jury since 1857? Their question for me was, well, why on earth would Americans have all layperson juries? Why would you not trust citizens to participate and deliberate as equals alongside professionals? They pointed in particular to the virtues of collaborative decision-making on the part of professionals and lay people, the advancement of written reasoned verdicts, so not general verdicts of guilty, not guilty, but lengthy rationales that were shared. And they also noted that this value of egalitarian and transparency was present in every societal domain, not just the legal system. So I need not go through all of the interview commentary on this, but just to note a few on this proposition that professionals and lay people can meaningfully collaborate as peers. They noted, and some of this is a feature of the high level of social equality that we see in Norway. So even during the time I was a visiting researcher there, I learned the salaries of academic colleagues were the same as the salaries of janitors who would clean their officers, and why shouldn't that be the case? There was this presumption that everyone can comfortably lead an upper middle class life, be guaranteed a certain amount of income, and so and also available, accessible, free education. So why would we not have professional judges and just ordinary citizens in meaningful conversation? And I apologize for these poor translations on my part. So most of them are very educated. Many of them have graduated from university, These are other very common themes in these interviews. Also the notion that lay and professional judges benefit from each other's expertise. So this idea here, quoting judges see a lot of cases, so they know, okay, this is a typical reaction. Not all rape victims behave the way lay people believe they should, so they have more experience, So if professional judges are seeing the run of cases, they'll understand much of what we all understand, as legal scholars, social scientists, about how, for example, victims in rape cases can be re-victimized. And so we have to be very cognizant in he said, she said, sexual assault prosecutions to come in, and intervene where lay people may have idiosyncratic or prejudicial views. There were also comments on the benefits of written reasoned verdicts. So this promotes understanding if professional judges can explain. There were cases where judges admitted they had serious concerns about whether all layperson juries actually understood the legal questions that were posed. And that is obviously a big source of worry. It can create appellate issues that might be avoided altogether if professional judges are able to weigh in. Decision-making can be aided. when you have written reasoned verdicts, that in some professional judges' view is actually a tool toward better understanding, hashing through evidence that had been shared in court, as opposed to just reaching a vote prematurely. And it also, they suggest, lent greater dignity to the process for defendants. The idea here being that if the defendant's going to be sitting in jail for 8 years, that defendant should at least know what the jury has said, right? So what the rationale behind the yes or a no. And this also promoted greater certainty, less unpredictability. You could immediately understand if there was a misunderstanding related to the law, and appreciate the reasoning behind verdicts. So, more broadly, what I saw in the conversations I had with professional legal actors was the sense that we have egalitarianism in the legal system that is no different from what we see in other societal domains in Norway. So here, illustrative quotations are whenever the welfare state is involved in your life, you're going to have a reasoned explanation. Why should juries be any different? It's very important to promote broader trust in law enforcement, in the government, to be able to offer reasoned verdicts. There was also a less of a sense of hierarchical differentiation in Norwegian prosecutors' offices as compared with federal prosecutors' offices that I've spent time in doing my US-based research, where you have in large offices multiple levels of bureaucratic review, a sense of entrenched hierarchy, as opposed to the open door arrangement, where you have all of the cases that come in assigned at random to line attorneys, as opposed to preference being given to those with experience in particular units. And is more of a sense of an open door culture. So this brings me to the question, and I bought the arguments, and I appreciated the sentiment behind this idea that when you have lay people, professional judges deliberating side by side, you are essentially putting more faith, more trust in ordinary citizens' ability, capacity to make sense of legal issues, to find seek justice in different cases. Then all of a sudden, I started paying more attention to sexual assault cases. And this is what I'm going to be continuing to write and think about. So the case that came onto my radar as I was wrapping up my research in Norway involved a case involving an 18-year-old victim. Her name was Andrea. She spent a weekend with her mother at a very popular skiing destination called Hemsedal. And the defendants in the case were three friends with each other, who planned to spend the weekend snowboarding. The victim, Andrea, had met one of these defendants, later joined the defendants and their friends at an after party. And over the course of this party, one of the defendants had offered Andrea a drug, MDMA or ecstasy. And after taking this, Andrea felt nauseated. She became numb. She doesn't remember much after that. But she was essentially raped by these individuals. So after the suspects in the case were arrested, they were first prosecuted in the district court, the court of first instance in Oslo. So here we had one professional judge and 2 lay judges were presiding over the case. And they ended up convicting the defendants of jointly raping Andrea in a trailer that they'd taken her to in a taxi. And the defendants were sentenced to 6 years in prison. So this was the district court, the court of first instance in Oslo. On appeal, a jury of, an all-lay jury, this is before the abolition of the all-layperson jury, a jury of 10 lay people acquitted the defendants. However, professional judges here in Norway, and this is became increasingly common and fueled some of the discontent with all layperson juries, decided to set this verdict aside. They exercised their discretion to do this. So it was then remanded for retrial by a new mixed court. This one, an appellate mixed court, had a majority. So 5 of the 7 judges needed to vote for the defendant's conviction. This was a mixed court, and instead only a 4-person majority voted for convictions. This meant that the majority of the mixed court, including 3 professional judges and 1 lay judges, believed that the defendants were guilty, but this was not enough. So the votes of 3 lay judges, even in this mixed court arrangement, won the day. And so what followed was very interesting. First, there was a tremendous amount of criticism of the all layperson, the 10-person jury that acquitted the defendants of rape. But then serious critique turned to the lay judges, right, who proceeded to allow for an acquittal even in the mixed court, mixed tribunal context. And what's particularly interesting to me, right, in looking at the backlash against this, right, lay judge outcome in a mixed court setting was, right, not only was it possible to critique lay judges in this context and more broadly lay participation in the legal system, which I found interesting, but because lay judges in mixed court or mixed tribunal settings are not unanimous in their rendering of verdicts. They actually sign their names to opinions. It was possible for the public to attack them very personally, and they were subject to, right, harassing messages to the point where one left the country. They on social media were attacked. And so one thing I'd like to be paying more attention to in a post-COVID world in which I'm returning and doing more field work is whether we see a trend towards, right, critiques of lay judges in the particular context of rape, right, sexual assault prosecutions in Norway, given what we also understand to be distinctive approaches in Norway to prosecuting these types of cases. So, which is something I could, speak at length about separately. But this is my interest and focus. So, is there something detrimental to even lay participation as we see it in operation now in Norway to have lay judges attaching names to verdicts, which may then open them up to a level of scrutiny and attack, which could affect outcomes in their cases. So I will conclude with that, and thank you all. It's really great to be part of this panel.
Thank you so much. That was all of these presentations were really interesting, especially for someone like me who doesn't know that much about international and comparative law. I feel like I learned a lot. So we have, as promised, about 40 minutes left in the panel. So I want to open it up to questions and comments from either from panelists or people who are in the audience who would like to. And so just raise your hand or put a message in the chat if you have a question or comment to add. Francesca?
Thanks so much for those presentations. I'm afraid I had to miss the first one, but I caught the two, the second and the third one, and really very fascinating material. So on the jury material, I have more just a general reaction to this discussion of juries, and that is that it seems like over time there's so many different rationales for using the jury. I mean, it's like they're 3 centuries or more than that, right? But even civil law traditions, like following the Napoleonic Code and the revolutions, most systems do get, even in traditional civil law systems that are based in canon law, they do get juries for criminal cases. And the debate just never ends on like how the jury is supposed to decide how who's going to be on the jury. Is it a mixed jury or is it just lay participation? And it seems like there's just every possible constellations. And so what you're looking at, I'm not sure I would say it's like a secular trend in favor of, just in general, in favor of more popular participation. I think it's kind of gone back and forth, and it's hard to with the times, you know. So it's really, it seems like it's up and down more than a secular trend towards more participation. And I think it'd be really interesting to look at sort of different kinds of verdicts that are generated, like before and after, right? Because most civil law traditions, they have the mixed form. They don't really have the pure form. So it'd be really interesting to see how much of a difference it is. But that's just a general comment, because I just find it really fascinating how it's an enduring debate, and there's so many different ideological components to the debate. But more on Noah's question, I don't have a good sense of areas of law outside of the human rights context for borrowing and where comparative law actually makes itself into judicial decision making. But on systems and which systems get looked at, I do think there are two, and you might have mentioned this, I apologize, my internet is acting up, but there are two quite distinct rationales for using comparative law in the constitutional domain, at least. And, one is I feel like that was the Roper use of it, is like, we're part of the world. And, we need to see what the world is doing, and we need to see what the consensus of the world is, or at least the merging consensus. And so there it's everybody, and the extent, so if that's the rationale, and it's this kind of cosmopolitan rationale where you don't have a discrete jurisdiction, but it's part of an interconnected world, then it's everybody. But if it's more the functional sort of rationale for, let's look at good solutions and see, who does it which way, and see if we can, get ideas, then it's more like systems where you look at other liberal democracies if you're the United States. And so then why not look at India, for instance, or but so that's my impression, is that there are these distinct rationales that then oftentimes get elided in practice, because it's really hard to have a good reason for, in the functional vein, for adopting one solution or another. And so what oftentimes judges do is they say, oh, like most people do it that way, and so we're going to do it that way anyway. So it's kind of this additional justification that goes to head counting, not like a real. And but I do think, in principle, you can distinguish between these two distinct rationales for looking to other jurisdictions. And the one first is this cosmopolitan one that requires, all 198 jurisdictions or whatever, or at least, a trend. And the other one, the functional one, the problem solving one, is just jurisdictions who are similar and have similar problems. But anyways, I found, both presentations really fascinating. Thank you.
Should we respond or take more questions, or Anna, you go first?
Sure, and I really appreciate that comment, Francesca. And I think you're exactly right, which is what makes the scholarship in this area a little bit maddening to look at, right? Because I don't think there are any clear trends. And what I've appreciated in looking at jury systems is how the very particular arrangements of jury systems reflect and reinforce, right, social norms that we see present even beyond the legal system. So whereas it can be tempting, right, for jury scholars to talk about particular right, procedural innovations as able to be, right, transplanted, right, borrowed from one to the next, as an anthropologist, the question's always, well, if you're to transplant, how much soil has to come with the tree, right? What has to be possible for us to speak of, right, mixed courts in a manner that are going to make sense, right, outside of Norway or within it. And so I think that's right. And changes that may seem to be, right, surprising as an outsider, it turned out, in Norway were absolutely in line with a progression of thinking, well, what makes the most sense for Norwegians, given that this jury system was adopted, right, as a fixture of right, English society, which did not share, right, many norms, and there were certainly interesting cultural divergences there. So I really appreciate that feedback and comment. That's right.
Maybe I'll just respond as well to Francesca's excellent points. I think you're absolutely right about the we're part of the world cosmopolitan use of borrowing or straight up comparisons with what the rest of the world does. And I would note in Roper and Atkins that there's a version of that, which is we don't want to be just like Somalia, or if there's a basket case country, let's align ourselves with most of the rest of the world as opposed to the outlier, right? In terms of what like countries do for functional problem-solving purposes, I think that's a very helpful point. But if I may throw a question back to you with your comparative experience, I'm becoming more and more interested in civil law countries and how they engage in this borrowing and the work of adopting or rejecting parallels. Because obviously the whole structure is organized differently. And in that regard, I'm fascinated by, you may know that before the Canadian Supreme Court settled same-sex marriage, a whole bunch of the different provinces' high courts had uniformly come down on the side of legalizing of civil same-sex marriages, as opposed to accepting the weak tea of domestic partnerships. And in the Hendricks case, the Quebec court, which didn't have to look to common law examples, cites the Massachusetts decision in Goodridge and rejects domestic partnerships as a vestige of separate but equal, and cited Plessy, which I thought was very interesting, because now we're talking about the one court that doesn't even cite to English Canadian precedent, doing it with respect to foreign and comparative law for both positive purposes and to distinguish the alternative. And I would love to know if anyone has thoughts on what that dynamic looks like in civil law countries, or are we all the product of LLM and JSD programs that are starting to meld global experiences, particularly in the realm of human rights?
Nancy, did you want to talk about
Sure.
that? Or
Yeah,
happy to-
sure. I wasn't sure, Francesca, if you wanted to respond, maybe stay on the point.
Well, yeah, well, that's a really interesting case. I don't know Canada very well, I have to confess. I just don't. And but so I don't think, I mean, it's interesting. I don't think if it seems like you're interested in knowing whether there's something systematic about like a civil law jurisdiction like Quebec uses foreign law. And so my impression is that, you know, if you're looking at like the ordinary courts that are doing sort of the civil, the criminal litigation, and sort of labor law, commercial law, they actually don't look at foreign law unless it's like binding internally because they're part of the EU. And I really just know the European systems. Right. So they don't, and it's really only their constitutional courts. But even their constitutional courts, at least the ones I'm familiar with, they don't actually do it very much. They have enough in terms of the human rights systems that they're already part of to cite. So like the German court doesn't really cite very much for like technically foreign sources because they have the ECHR, they're part of the EU, they have the international instruments that are binding sort of internally in the customary law. And so you don't actually get that much. It's counterintuitive, I think, because like at least these European civil law jurisdictions are, you know, very broad, you know, they in that they're very open to international law, but, you know, strictly speaking, comparative law. But I think it must vary too, because I do think, like, for instance, the Italian Constitutional Court, like Bill, I don't know if you were, if you ever knew Bill Nardini at law school, but I know him because when I graduated, we ended up in Italy at the same time. And he went and worked for the Italian Constitutional Court in their foreign law department. And he did a lot of research on American law for them. So I think that like some constitutional courts really do a lot of just straight up comparative law. And I don't know, you know, what that is systematically.
Right.
Nancy?
Thank you. Take my hand down. I've really enjoyed both of these papers. I mean, they're just, you know, kind of far afield from anything I do, so they were really informative. For Noah, what I kept thinking as you were talking, I so loved the idea of trying to figure out the principles and how, you know, what are the influences that drive some of these. But if I might introduce a note of cynicism, do you have to at some point address the idea that this is mostly results oriented, that Scalia opposes the influence of other countries, because it goes against the result that he would like to reach. If 98% of the countries were in favor of his position, he might have a different view of. So I don't mean to be unduly cynical, but I think it's hard to look at these cases, and particularly, your backlash and the anti-Sharia stuff and all of that, without thinking that there is that the content of the decisions, and I mean that for the majority as well. The majority comes up with a position and then reinforces it, and that's the way it's supposed to be, right? I mean, they say, of course, we are not borrowing foreign law, we are applying American constitutional principles and precedent, etc. And then you look around in the world and you say, aha, these other jurisdictions experiences and decisions support what we have already found, with the implication that if those didn't exist, the judgment would remain the same, if there isn't any. But as I say, there's imposing a kind of maybe either theoretical and normative matrix on what could look a little bit just like sort of power politics. It's not something that you don't want to do. You certainly want to continue with the project, but I think you would want to address,
right?
Just to me, it's the elephant in the room. As for Anna, I absolutely love this paper. In part, I have more familiarity with the Norwegian system because I was involved in a genocide trial there in 2014. So it was before all lay jurors. The question I have for you, I thought the example was really interesting, but are some of your conclusions or concerns based specifically on sexual assault, or are they more generalizable? I mean, the example you gave where, there's a highly unpopular decision made, and the names of the lay jurors are publicized, and so they suffer considerable negative consequences. Could this have come up in any context? I mean, is there something about sexual assault that makes this about, because the topic of your talk was, lay jurors in rape cases in Norway or sexual assault, but is it really about sexual assault, or is it about, unpopular cases that highlight some of the difficulties that can be inherent in the Norwegian system? And I just wasn't sure about that.
Yeah, I think that's absolutely right. This would be true of any unpopular decision, certainly, right? Corruption cases involving law enforcement officers. Sexual assault in Norway interests me because what I came to learn as I spoke to prosecutors is, right, unlike the prosecutors' offices I've spent time in here, right, where there was very much a sense that, often they would not take he said, she said type cases where there'd be unlikely to be right guilty verdicts. In Norway, as a matter of policy, very interestingly, they would take all of these cases, right? So there'd be a lot of young people who'd end up in court because of college scenarios that would never find their way in court here. And so I guess my broader worry and interest in the sexual assault context is whether there's a point at which policy priorities in a prosecutor's office might shift, not only because, right, their acquittals are not guilty verdicts, but because there is, public, popular backlash to even the participants, who are helping adjudicate these kinds of cases. But, as I go back and try to observe some of these, appellate mixed court cases and talk to folks again by way of follow-up here, I think it'll be interesting to see whether, as you point out, there's anything distinctive about rape, sexual assault cases, or whether this is just a broader feature of unpopular cases now having very convenient and publicly available scapegoats, the way that the judges.
If I could just follow up, it does seem like there's a good argument that community standards and lay participation is especially valuable in sexual assault cases, just because if you just look at, and I'm sure you have, the changes in rape and sexual assault law over the last, say, 4 decades, certainly in the United States, but I think in other countries, Western democracies as well, you see there's dramatic changes reflecting the cultural changes in society. And so it would be an argument, I think, in favor of retaining if not exclusive lay participation, but heavy or even heavier lay participation than you might have in other contexts where, murder is a bad thing and we understand what it is. And there's been virtually no changes in doctrines surrounding intentional killings, unintentional manslaughter, etc. Unlike what you see in the rape context. And so you might have a much stronger argument for we need to retain the people who are reflective of those cultural shifts.
Yeah, I really appreciate very helpful comments, particularly right in light of the far less onerous sentences right being given to defendants in Norway, to the point where there is always realistic discussion on the part of lay decision makers that these are individuals who may be convicted, but will also be returning, right? That they will be our neighbors. They will be
right.
At pickup at daycare alongside us. And so I think that the signaling of the verdict is important, even in, as you say, right, telegraphing what the how the social mores might shift over time.
Well, and if I can just one last point on they're coming back to us. They're also, and you realize this when you teach criminal law, as those of you do. I mean, when I teach rape, it's the only subject that I teach where not only, I mean, clearly members of my class, generally female members of my class, there's going to be, some of them who've experienced this, which you just typically don't have with other crimes, but also the male members of the class. It's the only crime where you can see kind of their mind spinning and thinking, holy cow, this could happen to me, right? And so it's not only that they're coming back because they are, only in jail for 6 years, they're also coming back because they're sort of part of the more, they're not, to the extent, and maybe this is more true in the United States than it is in Scandinavia, but they aren't the criminal element, they are us, right? They are there are college students, there are brothers, there are sisters, right? And so, yeah, you can see it for that reason as well. Anyway, sorry to go on.
Nancy, I'll just respond very quickly to your probably right on, but also cynical comment, which is that there's definitely been a shift among the conservative crowd. So with the anti-Sharia law boogeyman arguments, they were obviously not wanting to talk about foreign law. And now there's a whole group of scholars who are jumping in as amici in all of these hot button social cases. A lot of them tend to be foreign Opus Dei adherents in the abortion and contraception cases, but they are frequently from Catholic law schools in civil law countries. And they want their views considered before this Supreme Court, at least domestically. One way to look at that is that the liberal internationalists won, right? So we had influence, and now our political opponents are joining us in this effort. But I think there are lessons to be learned in how to do it better and worse. And this paper seeks to unpack those lessons. And I've been chastened by being on the losing side of some of these cases, and I've also won some of them. And so I'm trying to figure out what is it that's working. And one thing that is working is knowing your audience. So in Obergefell, we wrote a brief to the Supreme Court, 6 of us law professors, for an audience of 1, Justice Kennedy.
Right.
We hammered home the Irish referendum in a Catholic country on same-sex marriage. The court cites not our contribution, but the underlying arguments 4 times in coming to the conclusion that what's happening around the world matters, right? And now, obviously, Justice Kennedy was more open to this than some of the justices who at their confirmation hearings pledged never to cite foreign and comparative law.
Right.
But interestingly, after Obergefell, I got a bunch of calls from Singapore asking me to do similar work in the Singaporean context on what I think was basically an anti-sodomy statute, not an equal marriage case. And I began to think, what's going to work in conservative Singapore, and what's not going to work, right? And I think we're starting to see some inkling, and this is an attempt to kind of theorize from practice experience about more and less effective borrowing strategies, right? And we're seeing a bunch of this in the antitrust context, which is why I posed the question, should I focus on what I know best, or could I learn from, and there, whatever the relevant market is, helps to dictate whether a solution in a foreign country is adopted in another state. Because what happens in competition law might, particularly in the gray market for certain goods, spill over into their country, right? So there is less of what Francesca is describing as sort of the European countries or constitutional courts focusing on their regional and international and particular treaty commitments, and a lot of what Chief Justice Roberts worried about at his confirmation hearing, which is looking over the crowd and picking out your friends and picking examples or exemplars that, as you say, are results oriented. I think that is obviously the elephant in the room. But interestingly, there are like some practitioners facing off against each other in case after case. And I think some of these arguments are much more persuasive than others. And interestingly, some of you may be familiar with this, Yale Law School had a global constitutionalism seminar for years and years, and Paul Gewirtz would invite justices from around the world. And he tells me that the civil law jurists thrilled to this opportunity to talk about common approaches to distinctive problems in their own countries. So what's happening at the level of judicial dialogue, I think, is starting to happen at the level of reasoning, and that some of these arguments are better packaged, more persuasive, and map on to what it might be a new form of customary law, right, or customary international law. And that, I don't know if I want to go there, but this is a lot of the opinio juris that forms customary international law happening because one court, high court, is citing examples from another.
Maybe I'll just jump in and ask, and I have a few questions about your paper, Nancy, because we haven't talked about it as much yet. So I had a couple really small questions when you were speaking. One thing that I thought was really interesting was that it sounds like there's more than one judge at the trial stage. And so I was just curious, like how many judges there are at each of these levels. That's a very just small question about the institutional setting. And then I guess another really small question I had was what percent of the trial judgments are appealed? So my impression is that in the US, in criminal cases, a huge share are appealed when there's, because you can appeal as a matter of right and you can get a defense counsel for that. But I wondered if they're like sort of what the denominator was in some of those percentages that you were displaying. And then I guess, the big like looming normative question for me was, which I think about a lot whenever I read scholarship about dissents, is sort of, why do people dissent when they're not changing the outcome? It seems like a lot of work to write a dissent. And should we just like not have, and now you've suggested that it doesn't seem to have much effect on the development of the law. So like, should dissents be banned? Should judges like read your research and conclude that writing a dissent is totally pointless? Or is there something else like to be said for dissenting above and beyond this possibility of influencing the laws, or like speaking your truth, or maybe there's like a 1% chance that your dissent will have an effect down the line, but that might still be worth it for some judges. So I'm just sort of curious, like, what you think about that. I know it's a question that comes up a lot in the domestic literature about dissents and like why we observe them at all. So I'd just be curious what you think about that.
Yeah, I really appreciate the questions. And I probably, I should have perhaps spent more of my 20 minutes sort of setting the stage about international criminal trials, because I recognize that it is a system that not everyone is familiar with. But yes, there are going to Anna's point, there are no lay jurors in the international context. And so the trial chambers have 3 judges and the appeals chambers have 5 judges in all of these institutions. So yes, you can easily have dissents. Also, virtually every defendant appeals. The only ones who don't appeal there are some guilty pleas where included in the plea agreement is a promise not to appeal unless the defendant is sentenced outside of the range that is agreed upon. But I don't know the exact numbers. I could figure it out pretty easily. But outside of that context, and where the defendant dies in between, which, these are not your young kids, these leaders, or, the average age might be 60 or 65. So people do die. But absent that, virtually everybody appeals. They have almost no reason not to. And their defense counsel make a lot of money in some context doing it. So they certainly do. Not to mention that there's an ideological story to tell in a lot of these cases. But going to your larger point, yeah, the 2, I think, most compelling arguments in favor of dissents, one is that they help develop the law, but that's not the one that is most commonly advanced. The one that's most commonly advanced is kind of the flip side of the most common criticism of dissents. Early in the 20th century, particularly in the United States, dissents were really excoriated in the United States. And the main argument against them was that they undermine the authority of the law. The law should be seen as clear and authoritative. And we all know, and the judges themselves are promoting this conception of an understandable, non-ambiguous conception of law to the public. And to the extent that you have, well-regarded people saying, my brethren got it wrong, that is going to undermine the authority of the law, and it's going to undermine the legitimacy of the law. Right. And so that was sort of the narrative for many decades until about the mid-century, where proponents of dissent turned that on its head. And they said, sure, the appearance, unanimity creates an appearance of authority and legitimacy, but it's only an appearance, because we all know that there are, in fact, you can ban dissents, but you can't ban people from disagreeing. And to the extent that we know that there is disagreement, it undermines legitimacy not to have that transparency. The legitimacy of the courts are enhanced by an ability to actually speak, undermine away, right? Because then the public can actually read both sides. And even if the majority is not in fact overturned, even if the dissent never actually gains any traction, these ideas will be out there and the public can recognize what is actually going on with the law. And not to mention the fact that it's a myth that the law is, easy to understand, and all you have to do is get a law degree and then it will all, flow down from heaven. So I'm in subsequent work, I'm looking at other benefits and costs to dissent. One of the costs, that I'm looking at is delay. How much do dissent writing actually lead to delay in the international criminal context? Because delay and cost are a huge problem with international criminal trials. They cost a fortune and they can only be provided to a very small subset of offenders. And so to the extent that that allowing dissents delays proceedings, and that's a substantial cause. So I'm looking at that among other causes. Legitimacy is just a very hard, how do you empirically test legitimacy? I'm not sure that you can in this context.
Can I jump in with a question for Anna and Nancy? Okay, so Anna, my question for you has to do with what seemed like a very bad idea, which is signing your name in a world of social media to a lay result. I'm wondering if, because half of life is now lived online, if that has any impact on your thinking or on the Norwegian system, thinking about the rightness or wrongness of combining professionals with a lay jury, because it does seem to be an awful lot of abuse and loose naming and shaming that goes along with social media. And maybe if you're a judge, you have some protection or barriers that you don't have as a lay juror. For Nancy, I have a question and a pithy comment. So the question is, have you noticed any trends or observed anything about the background of those judges engaged in this epistolary tradition of dissent or concurrence or writing separately? Do they come from some, traditions or countries more than others? And the pithy comment was, when I was in law school, Owen Fiss and Tony Kronman co-taught a course. And I think Tony wrote the course description in the course bulletin. And then Owen dissented in a footnote from what the course was about in a co-authored class. So I thought maybe if the dissenters at the international plane are all Tony Kronman and Owen Fiss acolytes, that they came by their separate writing honestly.
And to the social media jury point, I think it's excellent. I'm reminded of the Derek Chauvin prosecution, right? The great lengths that had to be taken in a completely social media mediated trial to preserving juror anonymity. And even there, I had great concerns, right? It's very easy through internet sleuthing to take small, right, clues and cues we may have about someone's occupation, what they do, and then to identify particular individuals. And I've seen this, in the US happen all the time. And in fact, many defense attorneys rely on it, right, and being able to draw out opinions based on what may be posted, in Facebook comments or what have you. So I think this is a big problem. I think it's something that the Norwegian judges may need to rethink. The benefit of doing research in Norway and not the United States is, as I found, is you can essentially guess the email address of a Supreme Court justice, and then the next day have an afternoon chat in someone's office, and there's a great receptiveness to researchers and discussion on these issues. So I do suspect that in this move away from anonymity, there'll be great concern in high profile cases that folks will be deterred from participating, and they'll be which is not good for transparency, for comfort in deliberations, and that there may need to be a different approach taken.
Yeah, thanks very much for your questions and your pithy comment, Noah. That is hilarious. But you have just described project number 3. I have collected the data on all of the judges, including, obviously gender, background, what sort of jobs they had prior to becoming international judges. Were they judges in their home countries? Were they prosecutor, defense counsel, academics? There's a range. I've collected data certainly on their UN region, which region they come to, and particularly whether it's a common law or civil law jurisdiction. You would expect that common law judges would be more inclined to dissent than civil law judges. That has already been looked at by other scholars, and that expectation has not been realized. At the same time, there was an impact of if the composition of the court between common and civil law in the likelihood that some dissent would be drafted. So even if it was a civil law judge, the judge was more likely to draft a separate opinion when there are, common law judges on the panel. But yeah, I have not run the numbers yet, but I have all the data for that because I would like to see what sort of relationship. I will say that there, to some degree, the numbers are a little bit skewed because there are certain judges, and one of them from the powerhouse country of Guyana, that just issued so many separate opinions that it kind of skewed the data a little bit. This particular judge would just, and a lot of it wasn't, a lot of them were what we call concurrences, just, here's an interesting point that I would like to discuss. You do kind of wonder, and this goes back to Stephanie's point, the costs of dissent. You do wonder how many would be written if the judges didn't have paid legal assistance in the form of clerks, right? They might be less inclined to speak their truth if they were having to do most of it themselves. There's also one judge in particular who would write literally 800-page dissents that were essentially books, and touching on every issue in a very idiosyncratic way. And then, of course, he cited himself over and over and over again, which kind of drove up the statistics. But that's a long answer. I see we're basically at time here, so I want to make sure we don't go over.
Great. Well, yeah, this is perfect timing. We're almost right at 4. So thank you so much all for being part of this panel. I really wish we could have had you in Madison, but I really enjoyed it, and it was really, really great to moderate all of you. So thanks a lot, and have a good rest of the conference.
Very nice meeting you all. Take care.
Meet you. Thank you,
for moderating,
Stephanie.
Stephanie.
Take good care.